Okay, where we left off last time was with the case of Brown v. Board of Education in 1954. And that was the case where the Supreme Court held that states could no longer segregate their public schools. They couldn't have a white school and an African American school. And they couldn't do that because of the Equal Protection Clause of the 14th Amendment, which says that states have to treat all of their citizens equally. And at this point, either we've talked about that case in class or we're about to. And so you'll get more detail when we read that case together. But this was a big deal because it ended not only state segregation in schools, but also state segregation in other facilities like hospitals or train cars or things like that. So it was a big deal in ending that practice in the South, but it was also a big deal because it sort of opened up the Equal Protection Clause as something that people used whenever they felt that the government was discriminating against them. So not just on the basis of race, but on the basis of other things as well. So the court started getting all of these lawsuits from people claiming that they were discriminated against by a particular law or a government action, and that violated somehow the Equal Protection Clause. And so the court had to figure out, well, which of these lawsuits really have some merit and which ones don't. Because in some way, every law discriminates because it treats certain people differently than others. And most of the time, that's fine. It's arbitrary discrimination that is the problem. And so the court set up this kind of three-part structure, where if a lawsuit said that there was racial discrimination going on by the government, and the government was treating different races differently, then probably that was going to be unconstitutional unless the government had a really good reason to do it. And they called that strict scrutiny, but don't worry about that. Basically, if the government discriminates by race, that's unconstitutional unless there's a really good reason to do it. On the other hand, if a government discriminates by gender, treats men and women differently, that could be because of some sort of stereotypical prejudicial belief about men and women and who they should be and what they should do. But on the other hand, the court recognized that there were some occasions where it probably made some sense for men and women to be treated differently. So it said if it's a gender discrimination case, the government needs to show that there's a good reason for doing it. Not a really good reason, like race, but a good reason. So a little lower standard. And then if the lawsuit is for some other reason, I've been discriminated against by the government because of my age or for something else, then basically as long as the government is not acting completely irrational, the government's going to win. So in a race discrimination case, probably the government's going to lose. In a gender discrimination case, could go either way. And if for some other reason, then probably the government's going to win unless they're just being silly. And we're going to go over this a little bit more in class. Okay, 10 years after Brown, there was a constitutional amendment that ended the poll tax. The poll tax was something that was used in southern states where you had to pay to vote. And so that disproportionately burdened poor people, and African Americans at the time were disproportionately poor. And so it was kind of a backdoor way to keep African Americans from voting. And we added the 24th Amendment to the Constitution, 2/3 of Congress, 3/4 of states, to put an end to that in 1964. And then the next year, 1965, Congress passed something that was kind of a big deal called the Voting Rights Act, and it did a lot of different things. But the major problem they were dealing with was in deep South states like Alabama and Mississippi, something like 5 to 10% of African American voters or African American citizens were even registered to vote. And if you don't register, you can't vote. And so by making it difficult to register, that was another way southern states were keeping African Americans from voting. So under this law, what Congress did is they sent officials down to those states to register the voters. If the southern states weren't going to register the black voters, then Congress would send people to do it. And it also abolished literacy tests, which were ways that states again used to keep people from voting. If you couldn't pass this really hard literacy test, you couldn't vote, but only African Americans had to take it. So it got rid of that as well. And it was overwhelmingly successful in the sense that in states like Alabama and Mississippi, the voters' registration statistics of African Americans went from like 5-10% up to like 70-80%. So it was very successfully implemented. In the 70s, Congress proposed something called the Equal Rights Amendment, which said states cannot deny equal rights on the basis of gender. And it got through Congress. It got most of the states to vote for it, but you need 3/4 of the states, which is 38. And it never got there. It got to 37. And so it fell just short until last year. And if you remember from when we did the election presentations, one of the issues in the Democratic platform, if they won the state legislature in Virginia, was to ratify the ERA. And the Democrats did take over the legislature, the governor's Democratic, and so the ERA was ratified by the legislature. The problem is the deadline passed, and so nobody's quite sure what to do with that because 38 states had to ratify by a certain date. Virginia's ratification came too late, and so it's sort of up in the air now as to whether that's going to be added to the Constitution or not. Okay, Lawrence v. Texas. We've talked about Lawrence v. Texas before. A state may not punish someone for being gay. You can't, the government can't treat gay people differently. And specifically what that case said is you can't punish someone for having sex with someone else of the same gender. Texas did that. They punished this guy, and the Supreme Court said you can't do that. That's one of those fundamental rights under the Ninth Amendment that the state can't take away from you. And then in 2015, not that long ago, the Supreme Court held that states have to allow gay marriage, that marrying somebody and who to marry is a fundamental right, and that, like race, a state can't take that away from you unless there's a really good reason, and they didn't have one, the Supreme Court said. So gay marriage, which used to be a state-by-state issue, is now legal nationwide because the Supreme Court said it's one of those rights under the Ninth Amendment that, that the states can't take away. Okay, we're going to shift gears now to private discrimination. And that's discrimination not by the government through a law or through a government act, but by basically a business, by a private individual, or what we're going to look at is discrimination by businesses. And it was pretty common in the South to have restaurants or hotels that would not serve African Americans. So even in the 50s, early 60s, some of the best baseball players in the world, guys like Hank Aaron, Jackie Robinson, Willie Mays, would go to spring training in Florida. And when they were there, they couldn't eat in the same restaurant as their teammates. They would have to wait on the bus, and the teammates would bring them food out when they were done. They couldn't stay at the same hotel. And Congress put an end to this in 1964 with what they call the Civil Rights Act, which is a really, really big deal. It said no discrimination by businesses, and specifically that applied to restaurants and hotels on the basis of race, gender, or religion. So if you're open to the public, you have to be open to people of every race, of every gender, and of every religion. You can't discriminate and serve some people and not others based on race, gender, religion. So that was a really big deal. And one part of it was called Title VII, or Part 7 of that act, which applied not just to customers who you had to serve, but also to employees. You could not hire or fire somebody on the basis of his or her race or gender or religion. So not only are customers protected under this law, employees are protected as well. A lawsuit was almost immediately filed by a place in Alabama called Ollie's Barbecue, but also by a motel in Atlanta called the Heart of Atlanta Motel, who said Congress can't do that. They don't have any right under Article 1, Section 8. There's no power that allows them to tell businesses who to serve and who to hire. And Congress said, yes, we do. It's under our commerce power, interstate commerce power, which we looked at in class the other day. And the court agreed and said that because people in a restaurant or a hotel might have come from a different state, that's interstate commerce, and so Congress can step in and make a rule about it. And that case is called Heart of Atlanta v. U.S. Some other laws banning private discrimination. The Equal Pay Act in 1963 said women and men must get the same pay if they do the same work. And that law is very difficult to enforce because it's very hard to prove that two people do exactly the same work. But the principle is there. If the man and a woman are doing the same job, they have to be paid the same salary. Title IX of 1972, you might have heard Title IX before. Colleges can't discriminate by gender in athletic programs. And so what that means is, one of the things it means, is that if colleges offer 200 athletic scholarships to male athletes, they have to offer 200 athletic scholarships to female athletes. And what really throws that off in a lot of ways is football, because in some of the big-time football programs, you've got 70, 80 guys on scholarship. And so to make up for that, colleges started adding women's sports programs and giving scholarships, which was a huge benefit to women's sports. Things like women's soccer, women's volleyball, which didn't even exist at the collegiate level really before 1972, are now kind of a big deal. Women's basketball, women's softball. And a lot of that is owed to Title IX. And then lastly, there was the Supreme Court in 1986 that said, with respect to employees, not only can you not hire or fire based on gender or race or religion, if the workplace is what the Supreme Court called a hostile environment, or if you're sexually harassed somehow in the workplace, that violates Title VII of the Civil Rights Act. So that means not only some kind of like a quid pro quo, you'll get this promotion if you sleep with me or something like that. It also means if the office is somewhere where there are a lot of jokes about women told or a lot of racial jokes, and it makes you very uncomfortable to work there, then the business is violating the Civil Rights Act. So keep that in mind when you get into the workplace. Your employer has the responsibility to create a workplace environment that is not hostile on the basis of race or gender or religion. Two more laws Congress has passed. The American with Disabilities Act. You cannot discriminate against someone as a customer or as an employee on the basis of their disability. If a disabled person is able to do the job, you can't nevertheless fire them or refuse to hire them because of that disability. And then similarly, the Age Discrimination in Employment Act. You can't discriminate on the basis of age as a business against someone who's over 40. You can't say, no, I'm not going to hire you, you're too old, if that person is capable of actually doing the job. It doesn't apply to young people. A business can say you're too young, but they can't say you're too old. And then lastly, it is the 64 Civil Rights Act and other laws have said businesses cannot discriminate on the basis of race, gender, religion, age, disability. But Congress has never passed a law saying that businesses cannot discriminate against gays, against homosexuals. So what that means is a state-by-state issue. And some states have made it a crime or illegal for a business to discriminate against gays. Other states have not. And so if you look at the map, what you see on the map there is the darker states have laws in place that say businesses in that state cannot discriminate on the basis of homosexuality or sexual orientation. And in some of those states, it also says gender identity. And the lighter states do not have those laws. And what you look at, if that map looks familiar to you, it's because it almost exactly replicates the voting map, the election map of the states that Hillary Clinton won versus the states that Donald Trump won. And the darker states are Democratic states who have these laws in place and voted for Clinton. The lighter states are not. The only exceptions are Wisconsin and Michigan and Pennsylvania, which you see right there and there and there. And those states are kind of halfway in between. They have laws just preventing sexual orientation discrimination, but not gender identity. And those were states that actually Trump barely won in kind of a surprise. And so they're really very toss-up states, very, very close. And so it's really pretty amazing how closely that map replicates the election map from 2016. And the latest state to join that map is Virginia. Again, the Virginia legislature, when the Democrats took control, they passed this law saying it's illegal for a business to discriminate on the basis of sexual orientation and gender identity, and the governor signed it. And so this was just earlier this year in 2020 that Virginia joined that list.